There's a move afoot to require lawyers to have successors in place. Now, I'm not talking about business continuity. I'm not talking about the next generation to take over a law practice. I'm talking about the circumstance of sudden and unexpected either disability or death. Now, this topic probably does not apply to the larger firms, even the mid-sized firms, because they tend to have succession issues already in place, or if they don't, as some don't, they are large enough to be able to quickly deal with the issues of the clientele and other financial issues related to the death or disability of an individual lawyer. However, in the case of a sole practitioner, oftentimes there is nobody. The spouse is not a licensed lawyer and or not involved in the practice. It's important for three reasons. One is there's a case in Maine, the state of Maine, that suggests and actually says that the estate of the lawyer is responsible for the negligence of the lawyer. And one definition of negligence is that the lawyer failed to create a succession plan so that the interests of the client would not be adversely impacted by his death. Whether that be because of a missed statute or some other issue where the client is adversely impacted, i.e. negligence by the lawyer in the opinion of the court, the estate is responsible for that. The second reason is that state bars across the country now are beginning to look at this issue and say, oh, wait a minute, we've got to protect the client. Forget about the lawyer. We've got to protect the client. And one way to do that is to mandate that the lawyer will have a successor in place. The third reason is that it's important for the lawyer because the value of the law practice, a value that can be sold, is impacted if there's nobody to carry on after the sudden death or disability of the lawyer. In other words, if there's no protection for the clients within the law firm so that the law firm stays intact, then the value of that law practice goes down, and it unfortunately goes down very quickly. So there are three reasons, if not more, why this is an important issue. Having said that, it seems to me that it's an issue that can be dealt with practically without the mandate of the state bar involved, and without, and parenthetically I'll say that I think most state bars really don't care about the solo practitioner, and so the impact of this issue will be felt mostly by sole practitioners, and that's an economic impact I'm talking about. However, lawyers can deal with this issue very practically. How? Well, a number of years ago, my father suggested a very simple solution, and that is something as simple as a 3-ring binder. Before my dad died, and actually throughout his business career, he used to have the 3-ring binder in which he had all the assets listed that he owned and all the liabilities that he owed, debt and so forth. And he would talk to me and show me the 3-ring binder. And he said to me quite simply and candidly, if anything happens to me, just go to the 3-ring binder. You'll find the assets, you'll find the debts, all listed there, and you'll take care of them in an appropriate manner. Now, some people might say, well, gee, you know, if you've got a bank statement, you've got to go through years of bank statements. If you've got a stock brokerage statement, you've got to go through years of those documents in order to find out really where things are, what is left at the time of death or sudden disability. The point of the 3-ring binder is that this is a single location for a summary of all the assets and liabilities. It might contain the name of the title holder if it's not the decedent or disabled person. In other words, if there's joint ownership. It might contain a copy of the grant deed or other document. It would contain perhaps a copy of the deed of trust or mortgage and a copy of the note if it relates to the real estate property. Same is true with any other asset or liability, such as stock brokerage, information, a stockbroker account with the account number and the last perhaps monthly statement of that brokerage company, so on and so forth. Because once you have that starting point, you can go into the depth. You can find the additional documentation if you need it. But if you're dealing with a generation, and I know this is one step removed for most people today, but I remember my father-in-law didn't trust the bank, and he had money stashed all over the place. And just before we threw out a couch one day, we found some money stuffed into it. And I'm convinced that whether it be money in a couch or surreptitious bank accounts, whether they be in Europe or in another state or even in the same locale. In other words, it's a starting point, but it's a very effective starting point to make sure that everything is gathered appropriately and the successors have a starting point. This is not, in my opinion, something that ought to be mandated by the bar. It ought not be a rule of professional conduct. It ought not be considered negligence on the part of the lawyer, but just as a practical matter, it's something that the lawyer ought to consider and to his best or her best interest implement. Whether you use the 3-ring binder or not, this approach, this concept of gathering things in one place is an important one and one you ought to consider. Another impact of this process is that the quicker you can address these issues, the more likely you are to retain the value of the practice. And the value of the practice, the goodwill of the practice, is a saleable asset that can be used for the benefit of the heirs of the decedent or the successors of the disabled lawyer. If you have any questions on this, feel free to call me, Ed Pohl at lawbiz.com or 800-837-5880. Thanks for joining us today.